My name is Davies. I'm chairing the session this morning. Today is the first of 4 sessions that Green's List will conduct about conducting disputes and resolving disputes with the Commissioner. It's separated in, the 4 sessions are by and large separated into 4 definable segments. This morning's deals with, by and large, the pre-objection steps. The next session that's on the 13th of November will deal with objection and assessment steps. The third, on the 20th of November, will be concerned with conducting proceedings in the Administrative Appeals Tribunal. And the final one, on the 27th of November, will deal with conducting proceedings in the Federal Court. I think historically lawyers have not had a lot to do with the pre-objection steps with which we're concerned this morning. However, there have been really 2 things that have changed that scenario. The first is that the ATO is now concerned to, in an audit, to identify the real issues in dispute at a much earlier stage than has occurred in the past. And it's concerned to identify those issues, whether they might be both of law and of fact, but concerned to identify them in collaboration with the taxpayer. That's the first thing. The second is that with the embracing of alternative dispute resolution that's now occurred, disputes can either be resolved without objection at all, or they can be limited by agreement before one gets to objection, so that the participation of lawyers as a result in that whole process has become much greater. So this morning we'll just we have Keith Kendall, who will present a short presentation upon some of the particular matters relating to audit steps that might involve the work of lawyers, and after that presentation, that'll go through to about 8 o'clock. We'll have a short cup of coffee, and then after that, the panel will be here for a roundtable conversation. Really, we're quite interested on this side of the table to know what the experience of all of us has been in relation to what I might call pre-objection dispute solving. I should introduce the members of the panel. The one thing about Green's List is that it is very fortunate to have a wealth of very capable tax specialists, and the people sitting with me on the table today are no exception. Michael Flynn at the end, Lisa Hespe on my right, Orow on my left, members of the panel, and Keith, of course, who has done a bit of work for the presentation this morning, will lead the session. So I welcome them, I welcome you, and I'll hand over to Keith.
Thanks for that, Greg. Good morning, everyone. As Greg said, that I'll be speaking for about 20 minutes or so, just giving a bit of an overview about the audit process, which is essentially how the ATO investigative process, potentially leading to litigation, occurs. After that, then the panel will open up to take sort of an open-ended discussion. So the structure of my presentation will be as follows. Deal briefly with how an audit is commenced. Then talk about the provision of information, provision of documents separately. Some quick comments regarding process regarding oral interviews, then the interview itself, and some brief comments regarding what potential ATO responses are at the end. With the commencement of an audit, I suppose the first thing to realise is that there's something of a distinction between a review and an audit. The difference can sometimes seem a little bit semantic, but generally speaking, a review is a lot less formal. The ATO essentially treats this as an information collection exercise, whereas an audit, a lot more formal, often have something more specific in mind. There's frequently suspicion of wrongdoing at some point, and so in the event of an audit, a lot more care needs to be taken. Of course, review care needs to be taken as well, but an audit is a lot more serious. The ATO can ask for particular information using its investigation powers under sections 263 and 264 of the 1936 Act. Section 263 is the authority giving the ATO access to buildings and documents. It's their power of investigation, whereas section 264 provides the ATO with the power to demand information, so demanding the attendance at an interview, for documents to be provided, and the like. The particular request can be for a period of years as well as for a single year, so we might be going back some way back into the past for this. And another thing to realise as well is that the information required may be set out under just as general information collection exercise, or can be grouped under specific headings, and so more categorised information, which tends to be the more frequent practice these days. But one thing as lawyers that we should be aware of is that clients will often bring their accountants in first, most particularly around the compliance area, of course. Accountants are frequently the chief advisors, and so consequently they will often be the first professional advisors being brought in when the client's been served with an ATO notice. There will be the accountant brought in, and this can have implications for how legal advisors handle the audit process once we're called in to handle things. Now, in terms of providing information that the ATO is asking for, this can be in the form of documentary evidence, so as the name suggests, just handing over documents, allowing the ATO to view appropriate documents, take copies as necessary. In many cases though, the information will be oral. This will be in the form of an interview, so with the ATO asking questions, what was the purpose behind this transaction, how come things were structured in this way, etc, etc. And again, the process can be informal in many cases, so which raises issues regarding compulsion to acquiesce, to provide the relevant information, although in most circumstances it would probably be best to provide the information in those circumstances. However, that can lead to formal requests where the ATO invokes its formal investigatory powers. As we were saying before, this leads to more serious sort of proceedings, and further safeguards may need to be undertaken. However, in providing the information as is requested, it's worthwhile bearing in mind a very important point of how much information actually needs to be handed over and what information needs to be handed over. The principal concern for legal advisors in this context is legal professional privilege, which of course most of you will be familiar with. Long line of cases these days, LPP being based on documents or the communications being for the dominant purpose of providing legal advice or with litigation in mind. The big thing to remember about LPP in this context, I suppose, is to watch out for whether there has been a waiver of that privilege. So there's been a little bit of movement over the last 5 years or so as to what constitutes waiver, so it might be worthwhile going over whether any of those circumstances have come about. So, for example, referring to the legal conclusions with legal advice, even without having referred to those reasons, can constitute a waiver of that advice in that context, and so consequently that advice would need to be handed over to the ATO if it was asked for. This is, as I was alluding to before, with non-lawyers, particularly accountants, being the first port of call in most circumstances with ATO audits. This is a very live issue for us, and one thing that we need to be careful that waiver hasn't been impliedly invoked, as non-lawyers frequently don't have the same level of training and consequently awareness that legal advisors might have regarding the protections provided by LPP and the requirements for being able to claim privilege protection. And so it's something to watch out for. Of course, with LPP, the LPP requires the involvement of a lawyer at some stage. For those of you perhaps unfamiliar with the Pratt Holdings case from some years ago now, that case, which came from the full federal court, established that it's not necessary that the document in question needs to go through a lawyer in very specific circumstances. However, the lawyer still needs to be the driving force behind it. This leads on to the next point, though, which is the accountant's concession. Now, this is an administrative concession that operates similar to legal professional privilege, however, applies to accountants' work papers, accounting advice and the like. Whilst it's similar to LPP, unlike LPP, it's not a substantive common law right, it's not recognised, nor has the force of law behind it. It is purely an administrative concession that the ATO has created under its general administrative powers regarding the tax system. And it's a lot more limited than LPP is. So for our purposes, the thing to note is that it is available and might be something worth asserting if it is relevant. However, we need to note that it doesn't provide nearly the same protections as LPP, and being an administrative concession, the Commissioner has the power to lift it. And in essence, what the concession allows is that the ATO won't go and look at particular documents except in exceptional circumstances to try to simulate the privilege protection that LPP affords for accounting advice. However, like I said, in particular circumstances, the ATO can lift it, so it's one thing that needs to be kept in mind. Finally, the privilege against self-incrimination. This is something clients sometimes seek to assert, but it's worthwhile noting that this doesn't apply. That's been made clear since the mid-90s with the Devonk decision. However, that was reconfirmed only last month in the full Federal Court's decision in Binneto. So, if a client is trying to argue privilege against self-incrimination as a basis for not handing over particular documents, they're out of luck. So, in terms of handing over the documents to the ATO, once an audit is commenced, as legal advisors, first thing that we should undertake is to make sure that we've gone and viewed all the documents ourselves so that we actually know what's being handed over to the ATO. We've got a complete picture. And in reviewing these documents, go and consider whether any are protected by privilege. Because one thing to remember is that once privilege has been waived, it's waived for good. It can't be reasserted at a later point in time. Now, with privileged documents, disclosure of their existence still needs to be made. However, with the handing over of the list of documents or whatever similar mechanism is being used, that is the point at which privilege would need to be asserted if it hasn't already been. And so an acknowledgement that the document exists, but that privilege attaches and that it's being asserted and so being withheld. If there's a dispute as to whether privilege does attach to that document, then the document is likely to be put aside until that claim is sorted out. The request for documents is also likely to request specific documents, particularly ones that attach to particular transactions. And so with the ATO trying to identify, all right, what was going on behind this particular transaction here. The important thing overall by going through all these preliminary processes is first and foremost to have an explanation ready. So what was the purpose behind the way the transaction was structured? Why was it structured in that way? And not only at a global level, but particular steps along the way as well. It's important that everything is put into an accurate context, so there's no misleading impressions, or as little room for misinterpretation as possible. It's the opportunity to explain what the client's actions were, and it also ensures that the ATO's investigation is a meaningful exercise, because at the end of the day it's a fact-finding mission for the ATO, and that for the exercise to be meaningful, the documents need to be provided in their appropriate context. With the documents that are handed over, and also documents that the ATO might turn up with to the interview, it's important to maintain copies of these documents as well, so that a complete picture is maintained. And so the ATO might go away with documents once the interview has been concluded. But it's important to retain all the information, because frequently when documents are returned, they're not in the same order that in which they were provided, particularly if there's a large amount of these documents. And so it's important that we keep track of the client's system so that we essentially remember what it was that was told. In particular, when the ATO has documents from other sources, it's worthwhile knowing where those documents came from, who provided them. This would give some sort of, if at all possible to find out, this will give some sort of indication as to the extent of the ATO investigation. Might prove to be quite useful information in terms of trying to assess, all right, what is it that the ATO is actually asking, what is it that they're seeking to find out, and consequently that might provide some sort of basis on which the context can be provided. As I explained, the interview is really a fact-finding exercise for the ATO. They're trying to work out what actually went on here. But it's important to realise, or more to the point for the client to realise, that this is not a general conversation. Everything is recorded, and records and outcomes of the interview can wind up being very relevant to the can be very relevant to subsequent proceedings, including litigation later on. As legal advisor, it's our role to ensure that the interview is controlled as far as possible and that an accurate picture of the client's position is portrayed. Like I was saying before, with appropriate preparation, the opportunity or chance for misinterpretation should be minimised. Now, with oral interviews, these can be conducted informally or formally. Formal interviews are usually done on oath. The ATO has the power to demand evidence to be provided on oath. And in such situations, the ATO will often retain counsel. This takes an interview to a new level of seriousness, and consequently, the level of preparation necessitated in such circumstances is really akin to that we would provide for clients if they are entering into litigation. In such circumstances, well, particularly such circumstances, but whether or not the ATO retains counsel, it's worthwhile raising with the client as to whether they want to be represented by counsel as well in the interviews. In preparing clients for these interviews, the first thing on the agenda should be to prepare clients for likely questions, in particular obvious ones. So don't let the client go into the interview unprepared, not knowing what to expect, as well as being an understandably intimidating experience for a lot of clients and settling them down. Such preparation guards against the clients just talking without any purpose behind it. And they might wind up saying things inadvertently that create misleading impressions as to the purposes behind documents, behind transactions, which may be misinterpreted to the client's detriment. As we said before, it's important to have explanations ready at this stage, so when the predictable questions come up, there's the explanation ready that's provided. And again, it's important to ensure that you as the legal advisor have viewed all the documents, making sure that these are presented in the proper context, and in particular, any relevant privileges have been asserted. During the interview, it's important to listen actively, and in particular this means stopping objectionable questions. For example, any questions that are based on a false premise. It's also important, I was mentioning before about controlling the interview, and in particular this means controlling how the client responds to questions. This can be particularly important to make sure that the client doesn't inadvertently waive any privilege claim regarding the documents or any communications in question, as well as formal legal professional privilege. Similar waiver considerations apply to the accountant's concession as well. So it's important that the client is appropriately prepared for the questions that they're likely to be receiving, and so any adverse consequences, such as waiving privileges that the client would prefer to assert, are not inadvertently waived. And in particular, it's important that we don't let the client talk unreservedly. Answering questions directly is probably the most important instruction to give the client. Ask the question, answer it directly. Don't feel the need to fill in silences just with talking on. As I said before, during the interview, we're presenting material in the proper context. This makes it a meaningful fact-finding exercise, both for the, in particular for the ATO, and minimises any potential for misinterpretation, which might wind up causing difficulties later on. Once the interview's over, the potential responses from the ATO, there's the prospect that there'll be no action taken. The ATO is satisfied with all the explanations that have been given, appropriately documented, everything's above board, so nothing further is going to occur. Alternatively, the ATO comes to a position and will send through a draft position paper setting out its reasons, why it's come to the conclusion that it's had, leading up to an assessment. Assessment's not issued at this stage. However, the draft position paper is the last chance for the client to make any response or to put forward any arguments prior to a formal assessment being issued. So it's important at this stage to make sure that any submissions regarding facts or law have been put to the ATO, and that any evidence supporting these contentions have also been provided, bearing in mind, of course, overall, that the taxpayer bears the onus of proof in these circumstances, and so it's up to the taxpayer to establish their position. It's not so much up to the ATO to establish that their position is the one that's ultimately correct. Well, that concludes the formal presentation today, so I suggest we take a break.